Starting tonight, we have a good-sized panel, and we have Keith Lanthier as an individual. How was I for the Lanthier?
We anglicize it. It's Lantier.
Lantier.
That's okay.
All right. And then from the Competition Bureau, we have Richard Bellido and Anne Salvador. Okay. And then from the Federation du Francophone Canadien de Canada, Marie-France Kenny. And I think we decided, point of order, Mr. Richards.
Thanks, Mr. Chair. And I will be quite brief because I do want to allow lots of time for our witnesses tonight, so I will be very brief. However, there have been some reports out there, particularly in the media, about the fact that Elections Canada has contracts and there's payments and remuneration that's been made by Elections Canada to some of the witnesses who appeared before our committee on this study. As an example, we did have Paul Thomas appear before our committee, I think it was Monday evening, I believe, last week, and there was no indication given during his testimony or otherwise that he did in fact have a contract from Elections Canada, which is something that I think should have been disclosed. We can argue over whether that's a good thing or not. But certainly, as an example, as members of Parliament, we disclose any of our financial interests under the Conflict of Interest Code that we have for members of the House of Commons. And I think it's incumbent that witnesses should in fact disclose any financial interest they might have in coming before a committee. So what I'm asking you to do, Mr. Chair, is to write to Mr. Mayran, the Elections Canada CEO, and ask that he disclose any of the contracts that witnesses that have appeared before this committee testifying on this bill have with Elections Canada, and if he would also disclose the nature of the work that's been performed in exchange for that remuneration, Mr. Chair. Mr. Maran does report to Parliament through this committee, and I think we deserve to have those answers, and I think that disclosure should be made. So I'm asking you to write to Mr. Maran and ask for that disclosure to be provided to the committee. Thank you.
Same point of order, Mr. Christopherson, or a different one?
No, same one.
Okay.
Same one. I've raised this before earlier, and it was just left, and that was fine. We can live with that, but now they're trying again. And it's, are you and have you ever been a member of the Chief Electoral Officer's team? The fact remains that the government wants to ask any witness anything at all, they have that right. But it's not up to the chair to ask a question like this. It's part of the proceedings. So I'm getting a signal from you that maybe I can just stand down a moment, but
No, I'm just noticing that Mr. Sims had his hand up too, and that was a look of frustration that I'd like to get to our...
Well, we could go through this quickly if you would just say you're not going to do that.
I'd like to hear from all first, and then I will say...
Well, okay. Then it opens up a whole series of questions that are possible, that it's a government decision that they've decided that they want to run these witnesses through that filter, and they're entitled to ask any question they want. They spend most of their time talking out the clock anyway because they don't like the answers they get. But that's very different than making it part of the regular procedure that the chair of the meeting, almost like swearing people under oath, that people have to go through certain hoops and divulge certain things before the meeting can ever start. So, Chair,
that's
it's not
not
so
what I
much
heard,
it's not the question being asked, it's the fact that you're being asked to make it as the chair on behalf of everyone, and we reject that completely.
Okay. Mr. Sims, on that same point of order, before I...
It's my experience on committees, we always have a discussion preceding witness testimony. We have a discussion about who the witnesses are. Perhaps they should have brought it up then.
In a normal steering situation, that may very well have been the case. We didn't really get to that on this. Mr. Milan does answer to this to the Procedure and House Affairs Committee, and the committee's being asked to do that. But I'm going to take it under advisement for tonight, and let us go ahead with our witnesses.
If I could just very briefly add to...
Yes.
Because there was a couple of points raised, right, and refuting what I'd asked you to do. But I really think that at the end of the day, we had an example here of a witness who did come forward. This was not revealed, and I don't think it's the responsibility of members of Parliament here on this committee to have to look into the background of a witness. I think that's something when there is an interest when there is an interest like that, it should just simply be disclosed, and I think that's the reason why we're asking for that to be done.
I understand where you're at, Mr. Richards. Mr. Christopherson, did you want to jump in again, or you not?
My preference would be we just move on
Okay.
and drop all this.
Right. And on the same point of order?
Yeah, I appreciate Mr. Christopherson is a very passionate member and has deep feelings, and I respect that, but I do get frustrated with some of the analogies he makes, and his comparison of this to the McCarthy hearings, are you now or have you ever been a member of the Communist Party, is simply inappropriate. This is about trying to determine conflict of interest, not about trying to determine whether someone has passed the kind of obscene purity tests that the McCarthy Army hearings were imposing in the 1950s.
Thank you, Mr. Reid, and I'd like us all just take a deep breath, and let's go with our witnesses. All right? Mr. Lantier, please start with your opening statement, please, and we'll get back to that one at some point.
Okay. Thank you, Mr. Chair. I want to thank you and this committee for inviting me here this evening. As I indicated, my name is Keith Lantier, and I live in the riding of South Shore St. Margaret's in Nova Scotia. When I heard that these hearings were only going to be in Ottawa, I knew that I needed to do something. One option would have been to discuss it with my member of Parliament, but there was not enough time, and I was not confident that I would even get a response. And it was important for me to have a voice. Fair elections are the cornerstone of any democracy, and I must admit that in the past, I really didn't give it a lot of thought. I had very few expectations when it was an election. There was always a sense of accomplishment after voting, but it sort of ended after. That's where it ended. This changed for me in May 2011 federal election with the robocall scandal, and it intensified with the introduction of Bill C-23 in Parliament. Canadians from across this country are discussing the Fair Elections Act and thinking about the critical role that fair elections play in our democracy. So, from my perspective, there are two basic questions. Will the Fair Elections Act strengthen Canada's democracy by ensuring that every eligible Canadian is able to exercise this fundamental right to vote? Will it ensure that our elections are fair? While there may be some positive provisions in this bill, from my perspective, the answer to both of these questions is no. First, there are provisions in the bill to remove two methods of voting that have proven effective in ensuring that voters who do not have standard ID documents showing their name and current address can vote. These are the voter information cards and the vouching system. In the last federal election, there were over 100,000 Canadians who used a vouching system in order to cast their ballot. There are many reasons why they may not have the necessary documentation. 13% of Canadians move every year. Roughly 4 million Canadians don't have driver's license. There are many groups who may be negatively impacted if these changes are implemented. The Minister has repeatedly stated that these changes are necessary to ensure that there is no voter fraud. Harry Neufeld acknowledged that there were irregularities in 1.3% of the cases, but there was no evidence of voter fraud. He also noted that there are multiple reasons for these administrative errors. Mr. Neufeld made a number of recommendations, and none of them included the elimination of vouching or voter information cards. It is also extremely important that elections be independent and transparent. One of the problems with Bill C-23 is that it changes the rules by which election officials, including central poll supervisors, are selected. There are concerns that these changes will compromise the nonpartisan nature of these roles. The role of the Chief Electoral Officer will also significantly change. The bill will prevent him and Elections Canada from engaging with the public in the same way with respect to our democracy. This includes children and youth who are the next generation of voters. The student vote program reached over 500,000 students in the last election. The decline in voter turnout is clearly an issue. I think we can all agree. But not reaching the next generation of voters is clearly not the solution. Finally, when there is suspected voter fraud, there must be the necessary mechanisms in place to conduct thorough investigations. Bill C-23 simply states that an independent investigation will be initiated if there are sufficient grounds. The investigator will still have no power to compel witnesses to testify. That is a key reason why Canadians still have limited information about the improper use of robocalls in the last election. This is in sharp contrast to Section 11 of the Competition Act, where a judge can order someone to present evidence under oath or produce documents if the court is satisfied that the information is relevant to the inquiry. These are just some of the serious flaws with this legislation in the time that I have. It is for these reasons and other concerns why Bill C-23 must be withdrawn. All Canadians deserve to be part of this conversation, and not just those who have been able to make a written submission or appear before this committee. It is too vital to our democracy to be a ball bouncing back and forth between political parties. It is also my strong belief that any serious discussion of electoral reform has to include the possibility of adopting some form of proportional representation. In this way, every vote counts. Canadians want to be engaged in this discussion. I certainly have had a lot around my own area. And it is necessary to respect this. There can be no legitimacy without a comprehensive and consultative process. Thank you.
Thank you. Mr. Bilodeau from the Competition Bureau.
Thank you, Mr. Chair, for inviting us to appear today. Je m'appelle Richard Bilodeau et je suis sous-commissaire adjoint de la direction.
My name is Richard Bilodeau and I'm an Assistant Deputy Commissioner in the Civil Matters Branch of the Competition Bureau.
Deputy Commissioner in the Criminal Matters Branch. I would like to briefly describe the mandate of the Competition Bureau and give an overview of the Bureau's investigative powers under the Competition Act. The Competition Bureau, as an independent law enforcement agency, ensures that Canadian businesses prosper in a competitive and innovative marketplace. Headed by the Commissioner of Competition, the Bureau is responsible for the administration of the Competition Act, the Consumer Packaging and Labeling Act, except as it applies to food, the Textile Labeling Act, and the Precious Metals Marking Act. La loi sur la concurrence accorde au commissaire le pouvoir d'enquêter.
The Competition Act provides the Commissioner with the authority to investigate anti-competitive behaviour. The Competition Act contains both civil and criminal provisions and covers conduct such as bid rigging, false or misleading representatives, price fixing or abusing a dominant market position, among other things. The Competition Bureau also reviews mergers over a certain size to determine whether they would result in a significant lessening or prevention of competition. The Bureau is an investigative agency with no adjudicative function. If a civil case proceeds to litigation, the Commissioner can apply to a specialised competition bureau, or tribunal rather, or the courts for a remedy. The Commissioner may, at any stage of an inquiry, refer a criminal case to the Director of Public Prosecutions for prosecution in the courts. Criminal cases are typically referred when the Commissioner is of the view that the evidence shows that an offence has taken place. The Commissioner of Competition may convene an investigation based on information from a variety of sources, including, for example, market observations in response to formal complaints and as a result of immunity or leniency applications.
Criminal anti-competitive activities prohibited by the Competition Act. Under the immunity program, the first party to disclose to the Competition Bureau an offence not yet detected or to provide evidence leading to the filing of charges may receive immunity from prosecutions from the Director of Public Prosecutions of Canada as long as the party cooperates with the Bureau. Under the leniency program, the Bureau may recommend to the Director of Public Prosecutions that cooperating persons who have breached the cartel provisions of the Competition Act who are not eligible for a grant of immunity nevertheless be considered for lenient treatment in sentencing. Lorsque le Bureau a des raisons de croire qu'il y a eu une infraction à la loi sur la concurrence,
when the Bureau has reason to believe that a contravention of the Competition Act has occurred, the Commissioner can initiate a formal inquiry under Section 10 of the Act. When a formal inquiry has been initiated, the Bureau can collect information in a number of ways, either voluntarily or through the use of formal investigative powers granted under the Act and the Criminal Code. The Bureau's philosophy is that most companies in Canada wish to comply with competition law and regulations. The Bureau recognises this strong desire to comply and implements compliance promotion, education, information, advocacy, outreach and related programs in order to ensure that companies understand very clearly what is expected of them by the law. However, if companies with market power engage in anti-competitive activity, we will use the full force of the law to achieve compliance.
Powers under Sections 11, 15, and 16 are available for both civil and criminal investigations. In criminal cases, the Bureau also has access to additional powers under the Criminal Code. Under Section 11, the Commissioner may seek court orders to require oral testimony, written returns, or the production of records relevant to the investigation. Under Section 15 and 16, the Commissioner may seek orders to search and seize relevant information. In criminal cases, the Commissioner may also seek warrants or orders under the Criminal Code to produce information, conduct searches, or wiretaps. The Bureau must always seek judicial authorization to use these formal investigative powers. Merci de votre attention. Il nous fera un plaisir.
Thank you for your attention. I'd be happy to answer any questions you may have.
Any
No, I don't have
comments?
anything more to add to Mr. Villato's opening statement. Thank you.
Thank you very much. Ms. Kenny?
Merci beaucoup. D'abord, j'espère qu'on gruge.
Thank you very much. I hope that this won't eat into my 5-minute time allocation, but I'd like to take a moment to say that I'm the sole owner of 2 businesses. One's a consultative business that has already had contracts with, or business with Contracts Canada. When I became the chair of the Federation, I handed over the management of my 2 companies to a third party. So I don't know what that will mean exactly, but it would be my pleasure to give you any information you'd require, whether it be copies of the contract that I had. But I can tell you that I am here in my capacity as chair of the Federation, and that is the hat that I'm wearing today. So thank you for having invited the FCFA here today. The Federation is the primary spokesperson for 2.6 million French-speaking Canadians in 9 provinces and 3 territories. The Federation's goal is to promote the vitality of Francophone and Acadian communities, to contribute to the promotion of linguistic duality throughout Canada, and to stand up for the rights of French-speaking Canadians living in a minority setting. It also plays a leading role in a network of organisations and institutions of the Francophone Canadian Francophonie. To our knowledge, nobody to date has examined Bill C-23 in light of the obligations of the Official Languages Act. That is what we propose to do today, and in this respect, 2 elements of Bill C-23 are of grave concern to us. Let's speak first of all about Clause 7 of the bill. The proposed amendments would put an end to the CEO's power to communicate with the public to better familiarise them with the electoral process. For our communities, this would mean that the CEO would no longer have the ability to implement awareness programs to promote minority community Francophone citizen voter turnout. This civic, educational and awareness building role would henceforth be the purview of political parties. However, unlike the CEO, they are not subject to the Official Languages Act. So how is it that in the regions and the communities which are very far-flung, where there are minority groups, how will the Francophone vote be promoted? By limiting the ability of the CEO to communicate with Francophone communities in minority setting, it flies in the face of Part 7 of the Official Languages Act. This part, in fact, commits the government to enhancing the vitality of French and English linguistic minority communities in Canada and supporting and assisting their development and fostering the full recognition and use of both English and French in Canadian society. The Federation is therefore opposed to the amendments set out in Clause 7 of the bill. In fact, if there was a desire to amend Clause 18 of the Canada Elections Act, it should be to strengthen the obligations of the CEO towards the official language communities in a minority setting. This could take the form of an addition to the provision clearly indicating the role of the CEO, and this is what we recommend to the committee. The proposed amendments under clauses 18, 19, 21 and 44 of the bill are of great concern to us. Currently, the Canada Election Act stipulates that poll clerks appointed based on a list provided of candidates that the party has ranked first and second in the various ridings from the previous election. This causes substantial problems in terms of the ability of French-speaking citizens to receive services in the official language of their choice at polling stations. Far from addressing this problem, the proposed amendments further broaden the way of accessing other positions, including poll supervisors. Neither candidates nor party associations nor political parties themselves have obligations under the Official Languages Act. This means that Elections Canada, which is an entity subject to an obligation to deliver services in both official languages, wouldn't have any ability to ensure that the people on the candidate list for poll officials would be able to meet their obligations. So how can we ensure that this situation doesn't further damage Elections Canada and its ability to provide its electoral officials the opportunity to provide service in both official languages? The Federation is therefore opposed to the proposed measures set out in clauses 18, 19, 21 and 44 of the bill. The Federation also proposes that the positions which are filled based on the same processes in the current Election Act should be filled by Elections Canada and not by a list of candidates. Democratic rights guaranteed by the Charter not only include the right to vote, but also the right to effective representation, the right to poll and play a meaningful role in the election process. In our opinion, Bill C-23 in its current form is a breach of this ability of voters of Francophone communities to carry out these rights. Thank you.
Reid, 7 minutes, please.
Thank you, Mr. Chair. Ma première question est pour Madame.
My first question is for Ms. Kenny. Under the current Act, is there a right to vote and communicate with Elections Canada? Entrenched to communicate in both official languages or in either official languages Canada-wide, or are there limits applied for individuals in residence or residents in almost solely francophone communities? Well, in regions where over 5% of the population is French-speaking, Elections Canada has an obligation to provide services in French. Now, the fact of the matter is, and I'll talk about my particular situation, I'm a voter in Mr. Lakisti's riding. Hello, Mr. Lakiski, good evening. In the last election, I made an early vote, and when I went to the polling station, there was no services in French for anticipated voting. So there was a whole fight to determine how I would get service, and a whole host of people came to the fore to help me to vote because there was no real capacity there. And I think that if there were more polling stations that were filled by parties and candidates associations, the problem would only be worse. In my riding, and I don't know, and perhaps Mr. Lakiski can answer this question, I don't know whether there are lists of individuals who are bilingual that could be submitted, but in Regina and Lethbridge and Porapora and in Newfoundland and Labrador, perhaps in those particular regions, candidates wouldn't be able to submit lists of people who could carry out their duties in French. Now, according to the CEO, the obligation of the Act is to submit a report after each general election. That's his obligation under the official languages, under the Elections Act. Has he used this report to demonstrate how indeed he has provided services in both official languages to the extent of his ability, and that he has met his obligations under the Official Languages Act? Well, quite frankly, and I'll be honest with you, I haven't read the CEO's most recent report. Well, neither have most Canadians, says Mr. Lewiski. But I can tell you about my situation. In many polling stations, there are services offered in French. It depends on the polling station, but unfortunately it's not always the case that French is available. Now, when there is an institution that is subject to the Act that is having difficulty filling these positions, well, I have trouble understanding how, a list with individuals that don't speak French, how they'll be able to comply with the Act. Now, there are problems in various regions, and I can tell you that from one election to another, things vary. Another question. Clause 7 of Bill 23 proposes an amendment to Section 18 of the Canada Elections Act. Now, this provision reads as follows. The Chief Electoral Officer may provide the public, both inside and outside of Canada, with information on the following topics only, and there's a list. A, how to become a candidate. B, how an elector may have their name added to a list of electors. And C, how an elector may vote under Section 127 and the times, dates and locations for voting. How they may establish their identity and residence under D. E. Measures for assisting electors with a disability to access a polling station or advanced polling station. Okay, so perhaps we need another subsection here which indicates that the Chief Electoral Officer has an obligation to communicate with Canadians, communicate to them their language rights when it comes to Elections Canada, and which would indicate that they have a right to vote in the language of their choosing, and what in fact their rights are. I think that's a very good idea, that we ensure that French-speaking Canadians are entitled to vote throughout Canada and in bilingual regions. But in addition to that, there are current tools available, and I know that our communities do use them. These tools have been provided by Elections Canada. There is a guide on how to vote in your second language. So a newcomer who comes from Morocco, for whom French is a second language, or whose literacy level isn't very high, well, there are tools developed by Elections Canada available to people of limited literacy. And I know in our French language schools that there are tools or programs to encourage our youth to become more aware and engaged in the electoral process. Now, in my riding, and I'm sorry to come back to my riding again, I'm sorry, Mr. Lekiski, that I'm referring again and again to our riding, but in our riding there's never been a bilingual notice. All I've seen from Elections Canada was in English. All I've ever seen is I've never seen a vote for us in French. Votez pour nous en français.
The point of order to let Ms. Kenny know that under the new boundaries redistribution, I won't be representing Regina anymore, and I'm starting to get a sense that may be a good thing for me.
Moi, je m'attendais à avoir une affiche de vous, M. Lekiski, en français.
Then I'll expect posters from you, Mr. Lekiski, in French.
Madame Latendresse, you're up, please. Oui. I don't know what the split is here, so tell me.
Pas de problème. Je vais commencer rapidement. En fait, j'avais...
No problem. I'll get right into it. I have a couple of quick questions for Ms. Kenny as well. To begin with, I'd like to thank you for how you have commended my bill to ensure that officers of Parliament be French-speaking, and I hope that it would be good if we could get the same award, quote-unquote, for this particular piece of legislation, and I hope that we can reach a consensus as a result of that. I'd like you to give us some examples of what Elections Canada has specifically done to promote voting rights and voter turnout for people in your riding. Well, in fact, the tool that I was speaking about regarding literacy is broadly used in our communities, especially for newcomers. There are literacy organisations that use them to build awareness and to help people to understand the electoral process. These tools are much more far-reaching than what is provided for in the bill. Now, as far as information provided to our young people is concerned, the tools that are provided there aren't many tools provided. However, there are tools that help them to organise activities in their schools, and these tools are picked up on to quite a large extent. Well, it's very good to have this perspective, and you're the first to bring it to the table, and I think it's really interesting. That's all that I wanted to know, and I'll hand the rest of my time over to Mr. Scott.
Just off above 5 minutes.
Thank you. Thank you all for being here. I'd like to start with a couple of questions to our guests from the Competition Bureau. The first question is, Section 11 of the Competition Act provides for the possibility of a judicial order for oral examination. The Competition Bureau can go and basically we've been discussing it in terms of getting a judicial order to be able to compel testimony, and there's been a lot of talk about the need for that within the Elections Act. So my question is, are there safeguards in that provision against abuse with respect to the person who may be asked to be ordered to be a witness? Do you think they're adequate, or can they be, in light of maybe new case law, if we were to draft a similar provision in the Elections Act to Section 11 in the Competition Act, is there anything you would update it with by way of safeguards?
I can only speak to what we do at the Competition Bureau and how we use Section 11. Section 11 has three parts to it. Section 11(1)(a) allows the commissioner to seek from the court an order compelling somebody to provide oral testimony under oath. 11(1)(b) does the same thing in regards to documents from businesses or individuals, and 11(1)(c) provides for information that can be written questions that can be put to a business or a person, and then written responses to those questions. So before we get to the ability to seek Section 11 order, the commissioner has to initiate what we refer to as a Section 10 inquiry. So he has to have reasons to believe that either an offense has occurred under the Act, that an order from the Competition Tribunal, for example, could be made under Part 8 or Part 7.1 of the Act. And only then, when we are in inquiry, can we go to a court and ask the court to issue a Section 11 order. Now, to do that,
there's already some kind of reasonable grounds to be wanting this.
Well, to go to the threshold for a Section 11 order is we need to provide the court with an application. Essentially, it's an affidavit setting out the grounds for why we are asking a Section 11 order. There are two tests, essentially. One is that we are under inquiry, and that the target of the Section 11 order that we're seeking has information that's relevant to the inquiry. So the information has to have a link to the inquiry that we are conducting. And only then can the court consider issuing the Section 11. When we do draft our Section 11, and we do draft the order, and we draft the questions that we are looking for when it comes to documents and to written records, responses, we take great care to make sure that we're asking only for information that we need for our investigation, and also balancing so balancing the need for our investigation and also just being too broad in terms of the questions that we're asking.
And the safeguards that are written into the provision include that this an immunity use in the sense that use immunity, in the sense that it cannot be used. Anything that's given up during compelled testimony can't be used in courts. And Supreme Court has also held that derivative use immunity also would apply as well, right? You basically can't get something from a witness and then say, that gives us the idea to go and find something else. Without being able to show you would have found that something else otherwise, correct? So the Competition Act provides that a person that provides oral testimony under Section 11(1)(a), we cannot use that information against that person. Mm-hmm. It also provides that we can't use the information under Section 11(1)(c), which is the written responses to written questions. We can't use that information against an individual. It would be a different matter if it was a business responding to the questions. Has Section 11 proved to be, from your point of view, useful in investigations? If it were to be repealed, for example, would that in any significant way affect your investigations? It's hard for me to speculate on the impact that if you were to remove it. What I can tell you is that our investigations are fairly complex. They involve oftentimes anti-competitive conduct that impact large swaths of the economy. And all of the tools that we have, whether it's Section 11 or the ability to search, they're all equally important. And in any given investigation, we use some of them, and maybe just one of them, or maybe a few of them. But you do use Section 11. We do use Section 11. It is an important tool in our arsenal. We do use it. Great. Mr. Lortie earlier today talked about how he can't quite figure out why a provision that's proven so useful to go after significant system-wide economic crime can't be available in the context of maybe the most fundamental statute in our system, the Elections Act. So it's important that we know that it's proven important, at least in your context. Lastly, Mr. Lantier, are you an ordinary citizen, sir?
I believe so. Yes, I am.
Right. And you're not really in support of this bill. Do you know of other ordinary citizens who are not in support of this bill?
What I would say to that is what I made in my introductory remarks, is that this is generating a lot of discussion, whether it's in the media, whether it's just in the community that I live in. And I know there's going to be different sides to this. I mean, people are going to have different points of view. There's different points of view here on this committee. My concern is twofold. One is Canadians are talking about this. Canadians need to be heard, and there needs to be a process that takes that into account. Because without that process, and I mean, if it goes the way it is now, they will, in my opinion, it will severely affect the legitimacy of this. And so Canadians want to be part of that.
Thank you. Thank you, Mr. Scott. We'll go to Mr. Sims for 7 minutes.
Thank you. I'm sorry if some of this sounds repetitive, but when you're third, sometimes it's hard to come up with new material. But I want to start. I'm going to start over here at the end on the right. Ms. Kenny, I can hear you. You know.
Sorry.
That was your outside voice, Mr.
Yes, I apologize. I apologize.
I'm used to his outside voice. Trust me, it's as bad as the inside. Ms. Kenny, when it comes to the new rule where the poll supervisor is now given that job the same as a poll clerk or a deputy returning officer, it seems to me that has now become a little bit too excessive. I mean, it's one thing to have two people at the poll doing that, but if the supervisor was fully bilingual, would that be beneficial to areas that are above 5%, you say? There must be bilingual service?
Mm-hmm. En fait, non. Et c'est ce qu'on maintient, que cette application.
No, and that's what we're saying, that this will make it even more difficult, and what we're proposing is that these amendments be dropped, and that in the Election Act, since we want to amend it, that we ensure that other positions of that ilk, such as supervisors and officers, not be filled in that manner either. Now, the other thing that we're proposing is that Part 6 of the Official Languages Act guarantees access to Francophone and Anglophone citizens to positions in an equal manner. So, for example, in the case of Alberta, when you've got a list, regardless of who's submitted the candidates, how do you ensure that accessing the position of a poll official is available to both French-speaking and English-speaking Canadians? So when such an advertisement is posted, it must be posted in both English and French, and then otherwise, the Part 6 of the list can't be respected of the Official Languages Act.
Against any official language rights that you have and your group has. Mm-hmm. Would it be fair in saying that?
Oui, tout à fait. Et moi, quand je vais voter, je veux pas me sentir.
Yes, when I vote, I don't want to feel uncomfortable because I want to vote in French. I want to have the same rights as any other Canadian. And I can tell you that the last time I went to vote, it were the Canadians who were lining up with me that were feeling uncomfortable for me. And, I didn't get any support. Everything was done in English when I had to vote.
Section 11 that you talk about. I'm very interested in this because I think, obviously, this was the golden opportunity that was lost. That's just my political angle. You don't have to respond to that, obviously. Is Section 11, would you say in the business community it is a pretty good deterrent to use? People tend to comply. I mean, the whole goal here is for compliance, right, before you go to the DPP. So, obviously, Section 11, the business community knows about this, and they know that they will be compelled to testify. So do you find that you don't get to using Section 11 for that reason?
Okay, so Section 11 is an investigative tool. It's a ways to get information to allow us to determine whether or not the act's been violated.
How often do you use it?
We use it regularly. For example, in the last fiscal year, in 2013-14, we asked and got 26 Section 11 orders from.
That's more than I thought. Okay.
And it's an investigative tool. So when we do conduct an investigation, we have a lot of ways to collect information. When we go to third parties that aren't involved in the conduct that we're investigating, a lot of times asking the questions on a voluntary basis or provide information on a voluntary basis is sufficient. However, there are times when those companies that we are seeking information from either have commercially sensitive information that they cannot provide or are unwilling to provide to us voluntarily, or even that there are confidentiality provisions. So then in those instances, then Section 11 is a useful tool. When we seek information in a civil context against or from a target of one of our investigations, our default is using Section 11. It ensures timely information is provided to us in a timely manner, and that the information is complete. Maybe I can give you a bit of a flavor in terms of what we do with the information, because you referred to the DPP. Maybe I can turn it over to my colleague.
That was my next question. I want to know your relationship with the DPP. Go ahead.
I'll turn over to my colleague to answer that.
The Commissioner of Competition investigates anti-competitive conduct under the Act, both civil and criminal. Under the criminal provisions, once the Commissioner has developed a case, that evidence will be referred to the Public Prosecution of Canada, the DPP, who will take the decision to prosecute.
And that's the first time they're engaged in that investigation whatsoever?
They provide, along the way, through our investigations, they will provide advice, prosecutorial advice.
Okay.
But ultimately, in the end, it's their decision as to whether they will lay charges, whether they will proceed with a prosecution. We will make recommendations. We can make recommendations on sentencing. We can make recommendations on granting immunity or leniency. But ultimately, it's their decision.
It comes down to the evidence that you get, which Section 11 gathers quite a bit. Sorry, Mr. Belladonna.
Yeah, I wanted to add, that's on the criminal side. We do have civil provisions in the Act, and in the context of the civil provisions, it is Department of Justice lawyers, so not DPP lawyers, that handle our cases and litigate our cases. We do find ourselves in a different relationship where we are the client for the Department of Justice in those civil cases.
Oh, that's interesting. Thank you. Mr. Lantier, you, in discussions with people, do you think that, I'll say a statement, you would tell me if you agree. If people only knew what this will do, quick, if people knew how bad this is going to be, would the uproar be much larger?
I would answer that by saying I think people are aware. I think people are very informed. I think Canadians are very informed. And for me personally, this is my only avenue, other than writing a letter to the paper, to express, to have a voice. And so I am one of Canadians across the country who I think they understand. I mean, you can't, everything, whether it's in the paper, on the media, through news stories, I mean, this is well covered, so people know.
Thank you very much. We will go to a 4-minute round, and if we keep it tight to 4 minutes, we will get it in. Mr. Richards, 4 minutes, please.
Thank you, Mr. Chair. Mr. Lantier, I'd like to start with you. You did mention in your opening remarks some things that you were concerned with in the bill.
Right.
But you did mention very briefly that you thought there were some positive provisions in the bill. And I was just curious if you could elaborate a bit on what those are. Maybe I'll ask you some questions specifically. For example, the extra day of advanced polling that's being provided, would that be something you would be supportive of? Do you think that's a good thing?
I really don't have an opinion on that. I've never been prevented from voting under the current system, so it won't mean, I don't think, anything personally for myself. So,
okay.
No.
Okay, but I suspect you'd probably agree that it's a good thing to provide voters with as many dates and whatnot.
Well, I think it's important that Canadians who want to vote are able to vote. But I think if we have one thing that sort of encourages voting and maybe 4 or 5 things that discourages voting, I think we need to focus on the 4 or 5 things that discourage voting versus one that may enable people to vote.
Yeah, and we may not necessarily agree that there's things that discourage the voting. In fact, I think when you've got 39 forms of identification, there's lots of opportunity. And I think one of the problems, personally, is that some of the communication about these things. So, for example, the advanced polling. I mean,
right.
In your case, you've indicated you've never had any issue being able to vote on Election Day.
Right.
So that's fine. But there's other individuals, obviously, who wouldn't be in that same boat and would have reasons why they couldn't physically
Right.
be there that day or whatever. And I think sometimes that people don't realize that there's other options for them.
Right.
And we've heard a number of times in this committee from people who say there's no ability to vote. And this isn't specifically what we were talking about, advanced polling, but that's obviously one of the things. And I think if Elections Canada did a better job of communicating to people some of these options, like advanced polling or a special ballot, these kinds of things, I think it would really help to bring up participation. And I just wondered what your thoughts were.
Can I just respond to that?
Sure.
As I said, I mean, I've never been prevented from voting, right? If I wanted to vote, I've been able to vote. None of the people I know have been prevented from voting. And I guess this is my issue, is that Canadians, as I indicated, are talking about this. When we negotiate, when Canada negotiates a free trade deal, that takes years and years to, you're working out details back and forth. But for some reason, for the Fair Elections Act, we have to somehow get it within 6 months. That somehow we have to do all of this. And I think that, from my perspective, Canadians are being robbed of their opportunity. I'm here today, but I could have 50 people sitting in this chair who want to express the same kinds of issues. And we may disagree, but I'm here because of the process. The process has to be fair, and I don't believe it is.
Okay. Well, and I appreciate that, and I do appreciate you being here. I think it's important that we all have our chance to have our
Thank
views
you.
heard, and I think this process that we're undertaking
Thank you.
through this committee does provide that. I'm wondering, maybe I'll ask on something else. The idea of banning the use of unpaid debts, unpaid political loans. We've seen that in the past from some candidates, in particular leadership races and things. Using those to be able to get around donation limits. Is that we're obviously changing that, tightening that up. Is that something that you think is a good thing?
I would say two things. Number one, off the top, I really don't have that level of expertise.
Okay, fair enough.
But what I would say is that in the last election there were clear examples of overspending. So I think in order to have a fair election, we have to have a fair level playing field.
So making the rules
and so that
clear
whatever
would be good,
can be done in terms of transparency and accountability. But frankly,
you.
I didn't see that in the last election.
Thank you very much. We'll go to Mr. Scott for 4 minutes, please.
Back to the Commission Bureau, I was just wondering if in either your statute or your practice, are you under or do you feel to be under an obligation to provide written notice that you're investigating a company or somebody?
We do have a practice. I'll let my colleague answer that question.
So maybe I'll start with explaining our confidentiality provisions. So we do have strict confidentiality provisions under Section 29, which limits the disclosure of information except for instances of sharing with Canadian law enforcement agencies or for the administration and enforcement of the Act. We also are required to conduct our inquiries in private. However, within those bounds, in terms of targets of our investigations, we are giving them opportunities to engage in dialogue with the Bureau. Depending on circumstances, they may be notified that they are under inquiry, and the nature of that inquiry. I'm sorry?
Are you under an obligation to inform them?
Not under an obligation, no, but we do inform them in certain circumstances, depending on the case, depending on what provision of the Act we're investigating. And it also gives them an opportunity, perhaps, to resolve their liability. So that's with respect to targets. In terms of the public, if our investigation results in a prosecution or a civil proceeding, then the matter becomes public, becomes on the public record, and in most instances we will issue a press release. And then in other circumstances, if we resolve an investigation through a negotiated settlement, if we believe that the results of that investigation could provide guidance to the public in terms of how we enforce the Act, if there's a novel issue that we've dealt with, then we may issue a position statement.
Okay, so thank you very much. So just the moment, Bill C-23 would require the commissioner to give written notice that a person is being investigated, with some possibility of deciding I won't do that, but the primary obligation is they must. But we also have a provision that would make it it's very clear that the commissioner cannot provide after investigation information, such as the kind of summary that you suggested the commission, your commission can do on occasion for the benefit of the public. That's actually prohibited by Section 510.1. The other thing is the standard set out in the C-23 for a commissioner to even begin an investigation is an interesting standard, and I'm hoping the minister remains open to amending it. But it basically says that the commissioner may conduct an investigation if he or she believes on reasonable grounds that an offense has been committed. My understanding, at least in other areas of law, that that's a much higher standard than I'm used to seeing in criminal law areas, for example, to be able to even start an investigation. I understand from your presentation that the simple fact of market condition fluctuation might be enough for you to start an investigation. So is the standard of reasonable grounds a standard you would use, or do you have a much lower standard? This is not to get this is not to compel testimony or anything like this. It's just to start investigating.
It wouldn't be appropriate for me to get into sort of I'm not a lawyer, I'm not counsel for the Department of Justice. I wouldn't want to get into the legalities of reasonable grounds to believe in what that means. But just to be clear on when we can start an investigation, the commissioner has that ability to start an investigation, and he does so not simply if there are market conditions, but if he has reasons to believe that a company is engaged in anti-competitive conduct. So we do have to have some sort of behavior in the market.
Thank you very much. Thank you, Mr. Scott. We'll go to Mr. Lukiski for 4 minutes to finish this.
Thank you very much. Questions for our representatives from the Competition Bureau. I'm trying to get some clarity here because we've heard from members of the opposition throughout this examination of Bill C-23 that they believe that the Commissioner of Elections should have the power to compel testimony, something that you currently have in the Competition Bureau. But my point is simply this. The power to compel against an individual that, say, the Commissioner of Elections is trying to pursue or is pursuing couldn't ever be used because any testimony that came out of that wouldn't be accepted by the courts afterwards. My understanding in your particular case, the power to compel testimony is mainly due to or for administrative issues. Would that be a correct assessment? Or have you used this to try and compel an individual to come forward and provide testimony?
So we have used the power the ability to seek an order from the court to compel testimony from an individual. You're correct that in saying that if we get testimony from an individual, we cannot use that testimony against that person. We have used it in instances where we have documents that need some explanations, and for reasons maybe of that person being under certain the confidentiality obligations, we will seek a Section 11 1A order to compel testimony from that person. We've also used it in situations where maybe, to give an example of where we could use it, if companies are involved in an illegal criminal cartel under the Competition Act, oftentimes people don't put those illegal agreements in writing, and maybe oral testimony is how we would be able to get the evidence that we need to uncover it. But it is a tool that we use, but you are right, we cannot use that testimony against those individuals.
Thank you for that. And the reason I'm bringing that forward, of course, is because the opposition continuously says, and I've heard it from some of our witnesses as well, that look, if the Commissioner of Elections had the power to compel testimony, then we could have gotten to the bottom of this Pierre Poutine case already by merely getting witnesses forward. You could not use that information in court afterwards. That's why that would never be used. And I'm glad you confirmed that. What I would ask, however, is if in fact you were analyzing, and this may be an unfair question, but I'll ask it anyway, Bill C-23, comparatively the issue about compelling testimony, right, the ability to compel testimony, do you believe the ability that you currently have would enhance the ability of the Commissioner of Elections to receive the type of information that he would need in the course of his investigations? Or do you have any opinion.
I can't speak to what other agencies need or don't need in terms of investigative powers.
As I said, unfair question, but I appreciate that. Thank you, Chair.
Thank you. Well, then we will finish at that point and thank our witnesses for this hour of knowledge. And we thank you for coming tonight to do so. We'll suspend while we change the panels, please. Can you hear me?
I can.
Great, perfect. It's great to have you here tonight, too. We're about to start
okay, thank you.
This portion, and so we'll do that. Welcome back, committee. We'll start our second hour. We have the Honourable Preston Manning and Madam Fraser and Boris Wisniewski. But, Mr. Manning, we think we'll let you go first. We always like to go with the ones covering on technology to go first in case we lose you. So if you have an opening statement for us, please, go ahead.
Okay, well, thank you, first of all, for this opportunity. And I should make clear that I'm speaking solely on my own behalf and on behalf of the Manning Center for Building Democracy. I'm not speaking on behalf of the Advisory Committee to the Chief Electoral Officer, of which I'm a member. And I want to just confine my remarks to 4 points. I think you've been given sort of a one-page brief from myself. And the first is that I do think this is a commendable democratic initiative, Bill C-23, in particular because it seeks to eliminate those practices like robocalling, which discredit elections, parties, candidates associated with them. So that would be the first point that I'd like to make. Secondly, I do think there is merit in separating the administration of the elections from the enforcement of election law. I just think that this would allow the Chief Electoral Officer to focus solely on the election administration and allow the independent commissioner to focus entirely and independently on the law enforcement. The one area that I'd like to suggest where I think the bill can be improved, and I know you've heard a lot of suggestions for improvement, is that I would like to see the role of Elections Canada and Chief Electoral Officer strengthened with respect to the promotional and educational activities needed to increase voter participation. It seems to me that the biggest challenge that we have with the Canadian electoral system is not its fairness, although one has to address that, but it is this declining participation in elections generally. And if we profess to be Democrats, and I think no matter what our ideological or party divisions are, that we are all Democrats here, that everybody, Elections Canada, the parties, the candidates, the NGOs, should do everything conceivable to get that participation rate up. So I've suggested adding a section to the bill that lists the only topics on which the Chief Electoral Officer can provide information, to add a fifth clause that says public education and information programs to make the electoral process better known to the public and increase voter participation should be one of his duties. And then the last point I'd make, as some of you know, ever since I got out of Parliament, I've been a strong advocate of getting more training and preparation for people that are seeking elected office, not just themselves, but constituency organizations, campaign managers, anybody that's actively participating in the process. The old idea that we can learn on the job, which has been the conventional wisdom for a long time, I think in this age of rapid communication and is just not workable. So I've been involved in trying to persuade people to take training if they're going to get into the political arena. And there is some confusion when you run into prospective candidates and campaign managers that as to whether investments in training prior to the election might be considered an election expense or a contribution in kind. So to eliminate that confusion, I'd propose an amendment to the bill that simply says that training course expenses, including expenses for education on the subject of the Act, or on election campaigns are not election expenses, personal expenses or electoral campaign expenses under the Act. And I do think that one change would make it crystal clear. Our lawyers say that actually these things are not expenses now, but it is unclear. I think that one change would make that crystal clear. So those are my 4 points, Mr. Chairman. I won't take longer, and I'd be happy to elaborate on any of those or to answer any other questions that you might have.
Great. Thank you, Mr. Manning. We will get to you with questions, but first we're going to go. Madam Fraser, would you like to go next, please?
Thank you, Mr. Chair. Monsieur le Président, je suis heureuse d'être parmi. Mr. Chair, I'm glad to be here with you, and I thank the committee for inviting me to make my observations regarding Bill C-23. I'd like to begin by stressing that these are personal remarks. it is not my desire to put words in the mouth of the Chief Electoral Officer of Elections Canada or the Advisory Committee of which I am co-chair. In an effort to be transparent, I wish to advise the committee that I received $2,450 for my participation to date in this advisory committee. I also worked as a member of the selection jury for various positions of Elections Canada and received for these services the amounts of $976 in 2014 and $3,240 in 2012.
Serving as the Auditor General of Canada for a 10-year term, which ended close to 3 years ago. The Auditor General is one of 7 officers of Parliament who play a very important role in our democratic system. The Privy Council Office refers to these officers as agents of Parliament and states, and I quote, "Agents of Parliament are a unique group of independent statutory officers who serve to scrutinize the activity of government. They report directly to Parliament rather than to government or an individual minister, and as such exist to serve Parliament in relation to Parliament's oversight role. Agents normally produce a report to Parliament to account for their own activities, and their institutional heads are typically appointed through special resolutions of the House of Commons and the Senate. To maintain the independence of the agent, the degree of influence exercised by the executive arm of government is minimal." End of quote. L'indépendance des agents du Parlement, tant concret.
The independences of officers of Parliament, both concretely and in terms of appearance, is crucial to their credibility and their ability to carry out their mandates. And I was very pleased that the government acknowledged the importance of this independence in 2007-2008 when it changed a number of administrative policies. These amendments transferred responsibility to implement and enforce these policies to officers of Parliament, a responsibility which prior to that was in the hands of a minister. At the time, the Treasury Board Secretariat worked closely with officers of Parliament to address these concerns.
This bill, which would affect the independence of the Chief Electoral Officer and his organization. First, Article 18, that restricts the Chief Electoral Officer's communication with the public to certain specified, limited information. Outreach activities, encouraging people to vote, and educational initiatives would no longer be permitted. An independent officer of Parliament should be able to bring any issue that he or she believes important to the attention of Parliament and the public. Secondly, Article 20 will now require the Chief Electoral Officer to obtain Treasury Board approval to, quote, fix and pay the remuneration and expenses of persons having technical or specialized knowledge, end of quote, engaged on a temporary basis. This is clearly an infringement on the independence of the Chief Electoral Officer. In comparison, the Auditor General Act explicitly states that the Auditor General does not require the approval of the Treasury Board. In addition, the government's contracting policy specifically exempts the officers of Parliament from obtaining Treasury Board approval. I am also concerned that should this article be adopted, it could create operational difficulties for Elections Canada in managing an election, given the hundreds of people with specialized assistance that it requires. En 2005, le Bureau.
In 2005, the Office of the Auditor General carried out a management audit on the operations of Elections Canada. At the time, we found that Elections Canada effectively planned, managed and administered the federal electoral process whilst respecting the relevant authorisations and playing a crucial role in ensuring that the election be carried out fairly and transparently. I encourage the committee to ensure that the bill does not chip away at this foundation.
Clerk of the committee and House staff for their assistance to me in preparing for this hearing, and I would now be pleased to answer any questions that committee members may have. Thank you.
Thank you. I echo your thanks to the clerk, because without her I'd be lost too. But we'll go to Mr. Wisniewski for 5 minutes or less, and then we'll do questions.
Thank you, Chair. Committee members, I'd like to address the issue of preventing electoral fraud. The assumption that organized electoral fraud happens elsewhere in countries we send Canadian observers to, and not in our Canada, can no longer be assumed. The Newfield report states that in the Etobicoke Centre, there was judicial agreement that despite the presence of irregularities, there was no evidence of fraud or ineligible voters being provided ballots. I support all of the recommendations of the Newfield report. However, the above statement would have been more accurate if it had added that there are legal limitations to the Elections Canada Act and the Privacy Act that practically limit, in fact make it impossible for evidence of fraud from being admissible or proven in court. As an example, the table in Annex C of the Newfield report points out that in statistical analysis of 3 by-elections, ballots handed to people not on the voters list, yet no registration certificates were completed, occurred in 0.4%, 0.5%, and 3.8% of cases. Yet in the court sampling of 10 polls in Etobicoke Centre, the number was 48.2%, almost 1,000% higher. I've been an electoral observer overseas and organized electoral observer missions on behalf of NGOs, Canada, and the OSCE since 1991. When we have found such patterns of statistical anomalies, we've concluded the likelihood of fraud. However, the Canada Elections Act precludes statistical findings of fraud. The standard is to prove that individual ballots are fraudulent. However, the Elections Canada Act and the Privacy Act prevent us from questioning the voters who cast those ballots, nor could we compel elections officials to answer questions. A legal catch-22. In June of 2011, after being given an anonymous tip that ballots were being handed out in one poll without IDs being shown, we followed up with a statistical analysis of all Etobicoke Centre polls. We found disturbing results. For example, in poll 31, voter turnout increased by 70%, and the Conservative vote percentage increased by 50%. When poll 31 documents were examined at Elections Canada Secure Facility, 20% of all votes were by registration certificate, 1 in 5, whereas the overall Etobicoke Centre and Canadian averages were 5%, 1 in 20. Of the 86 RCs, a majority turned out not to live in the poll. Towards the end of the Superior Court hearing, Elections Canada tabled emails in which both the DRO and registering officer in poll 31 made contradictory and false statements as to whether non-eligible voters were allowed to vote. Has Elections Canada investigated these officials? There were a significant number of other similarly problematic polls. To maintain the public's confidence that those elected by the narrowest of margins are in fact a reflection of the people's will, statistical evidence must be allowable, and the legal standard ought to be the balance of probabilities and not beyond the shadow of a doubt. In addition, I disagree that the Office of Commissioner of Elections independence should be jeopardized by putting it under the wing of a government department. However, I also believe that an arm's-length investigative unit be foreseen in legislation in cases of serious allegations of administrative failures or fraud against Elections Canada officials. Both investigative bodies must have the powers of subpoena and to compel people to give evidence. I also suggest that there be a legal requirement to bring resolution to cases within a 1-year time frame, as opposed to the decisions rendered 5 or more years after the fact, making them moot, as by then the next federal election has occurred. In Etobicoke Centre, alleged vote additions occurred in an atmosphere of vote suppression, including the disruption and shutting down of 2 of the strongest Liberal polls by identified Conservative campaign team members, including the campaign manager. Consequential penalties need to be applied in cases of direct vote suppression. Campaigns whose team members engage in such tactics need to face the penalty of having their candidate's election disallowed. A democracy's foundational social contract is we all have a voice. Young or old, it's one person, one vote. Rich or homeless, it's one person, one vote. White or Aboriginal, it's one person, one vote. If the rules that provide the framework for the act of voting are overly restrictive, the representative nature of a government is questionable. If rules are not followed by officials due to lack of training and resourcing, we have no confidence in the results. If rules are broken by vote suppression or vote addition, a government's legitimacy is called into question. And if the government introduces Bill C-23 without serious amendments, it will have facilitated all of the above.
Mr. Wisniewski, we'll go to questions. 7-minute question round. Mr. Lukiski, you're starting tonight.
Thank you very much, and thank you, Mr. Manning and Ms. Fraser and Mr. Wisniewski for being with us today. My first line of questions, I guess, will be directed to both Mr. Manning and Ms. Fraser, and it deals with the provisions contained in Bill C-23 to remove the Commissioner of Elections from Elections Canada and place him under, or at least within the office of the Director of Public Prosecutions, because our contention is that this would give far more independence to the Commissioner of Elections. Currently, although the Commissioner himself thinks he does have independence, under questioning from myself at his appearance here, it was ascertained that, in fact, the Chief Electoral Officer, Elections Canada, in other words, can hire and fire the Commissioner of Elections. The Elections Canada controls the Commissioner of Elections' budget. Elections Canada can direct and compel the Commissioner of Elections to conduct investigations, whether or not the Commissioner himself wants to. The CEO of Elections Canada can stop an investigation, an ongoing investigation, by just requesting that investigation be halted. And to me, that's not independence whatsoever. What we are suggesting is that the Commissioner of Elections be removed from that, so then he would have, number one, the ability to control his own budget, to hire his own staff, to determine what investigations he wishes to conduct, but he's not compelled to do so. And I think by anybody's, I guess, common sense examination, that would be very, very apparent that that gives the Commissioner of Elections far more independence than it is now. So, Mr. Manning, I know you suggested that you like that part of the provisions of Bill C-23, and I think, Ms. Fraser, you disagree. So I'd like to hear both your comments on why you support your particular position and the position as advocated by the government in Bill C-23. Mr. Manning, you first. By the way, Mr. Manning, I should start off by asking a question, although Ms. Fraser has always voluntarily disclosed her remuneration by being on the advisory board for Elections Canada. I should ask you the same question, Mr. Manning. Are you being remunerated by Elections Canada?
Well, I think there's a contract that says I am, but I haven't got a check and I haven't sent a bill. And I've only participated really in one teleconference with that, and it'd be my intention not to bill Elections Canada for whatever advice I could provide. On your question, I came at it more from the other angle of functionality rather than independence. That I felt that the more the Chief Electoral Officer can focus solely on the administration of the election, that would enhance his function, and therefore the separation was a good idea. If people are worried about the independence of the Commissioner under this new arrangement, I do think there are ways and means of strengthening that. As I vaguely recall the statute that establishes the function of the Director of Public Prosecutions, there are a number of provisions in there to guarantee his independence from the Attorney General, and one might look at that statute as a way of increasing independence if that's desired.
Yes, Ms. Fraser, your comments?
I think the major difficulty that has been raised with respect to putting the Commissioner under the Director of Public Prosecutions is on the exchange of information. It is very important that the Commissioner work with Elections Canada in order to get all of the information that they need in order to conduct investigations. And the current legislation around privacy, etc., there are no provisions in the Act that would allow for that exchange of information.
Are you suggesting that the Commissioner of Elections would not be able to get information from Elections Canada?
It is my understanding, yes, that there could be difficulties for the Commissioner in obtaining that information from Elections Canada. There are a whole series of legislative requirements within the government about exchanging information between departments. So that is something that I would certainly, if the committee continues with this move, that they look at that. The other, and I'd just like to make the point that it is generally accepted in regulatory agencies that the administration and the investigation go together. That is the case in the Canada Revenue Agency. It is the case that the Ontario Securities Commission, which actually in fact goes much further and into adjudication. And if I could just read you an excerpt from the annual report of the Public Prosecution Service, the DPP. It says, the Public Prosecution Service of Canada prosecutes charges of violating federal law laid following an investigation by a law enforcement agency. The PPSC is not an investigative agency and does not conduct investigations. The separation of law enforcement from the prosecution function is a well-established principle of the Canadian criminal justice system. So this would be something new for them. I think, if there are concerns about the independence of the commissioner vis-a-vis the chief electoral officer, some of the provisions that are being put in around, appointment, tenure, could certainly be put into that act to strengthen that independence.
Well, the independence factor is something I think is extremely important because, as I said before, right now, there, in my view at least, from my seat, I don't see any independence that the Chief of Commissioner of Elections has, only because everything is controlled by Elections Canada. Hypothetically, what would happen if, for an example, the Commissioner of Elections was called upon to investigate Elections Canada itself or an individual within Elections Canada? I think that's a huge conflict right now because, as I said in my opening remarks, the Chief Electoral Officer not only can direct an investigation to begin, whether or not the Commissioner of Elections wants to commence an investigation, he would be compelled to, and also the CEO of Elections Canada could stop an investigation. And I think that's a conflict, at least from a perception standpoint, that shouldn't be allowed to occur.
I guess I don't know all the specifics of the Act. I've certainly not seen anything in the Elections Act which would allow the Chief Electoral Officer to stop an investigation. I can only rely on the testimony of the Commissioner, who indicated very clearly that he had the necessary independence, operational independence. And if I could just add, if you talk about a question of perception, I don't know that it's any better to have the perception that the Commissioner will indirectly report to a Minister of the Crown.
Mr. Christopherson, 7 minutes. Mr. Christopherson.
Thank you very much, Chair, and thank you all for being here. And I have to say, Madame Fraser, seeing you at the end of this committee table is like looking up at the ridge and seeing the cavalry coming over to save the day. I really appreciate you stepping forward. Anybody who spends time with Sheila Fraser is having a good life. Come on. No, I very much appreciate you being here because you, in my view, you're probably the most trusted Canadian in the country, and I think a lot of people rely on you to give them the straight goods. And so I just want to pick up on just some very, very straightforward questions. The first thing I want to do, though, is I'm sure you've been following the hearings at least somewhat, and I have been finding it very troubling to see the way that the Chief Electoral Officer is being portrayed. At the very best, just a stakeholder, and at worst, an enemy or an opponent of the best electoral laws we could have. And yet, that position is equal to the one that you held of Auditor General in terms of being an agent of Parliament. And I'd just like you to comment on the importance of the Chief Electoral Officer being seen in the same way that you were when you were the Auditor General, and that we currently see Mr. Ferguson as a champion of the Canadian people and not just some stakeholder who's trying to grab as much as they can out of it for themselves, which is the way the government is portraying the Chief Electoral Officer of Canada. Just your thoughts, Madame.
Well, as I said in my opening remarks, the officers of Parliament really do play a very important role in our democracy. These jobs, we don't take these jobs to win popularity contests. We do our work with objectivity. I know that there are certain audits that created, I don't quite know how to phrase it, but I'm sure I was not on, the Christmas card list of certain people after certain audits, but we do our work, we respect our mandates, we do it in an objective and a fair way. And it troubles me greatly, I would say disturbs me greatly, to see comments that are made, and I will be quite blunt, by the minister, which he made today in committee, attacking personally the chief electoral officer. This serves none of us well. It undermines the credibility of these institutions, and at the end of the day, if this was to continue, we will all pay, because no one will have faith in government, in chief electoral officers, or a democratic system. And we can have differences of opinion, and that's what a democracy is for, is to be able to express freely our differences of opinion. The officers of Parliament should be able to come to Parliament and explain issues that they see in proposed legislation. I am sure that if the legislation goes through, the chief electoral officer will respect it and he will follow it. But to actually attack him for bringing forward his concerns, I think, is totally inappropriate.
Thank you, Madame. And I don't think that point could be made any better or more emphatically and with more credibility than coming from you. Thank you for that. Moving on to some of the details now. One of the concerns you raised in your remarks was the need now for the chief electoral officer to get approvals from Treasury Board, something, again, back to the Auditor General, to use the comparisons that you never had to go through. Could you expand a bit on the comments you've made here, please?
In the administrative policies of government, if we go back previously, the officers of Parliament were included with all the other departments and agencies, and the administrative policies all applied to us with no recognition of the independence that was needed for officers of Parliament in the management of their offices. We began discussions with the Treasury Board Secretariat about this, and said there were really some provisions which were really inappropriate and didn't recognize the independence that was required. And the Secretariat actually was very cooperative, worked very diligently with us. There were a large number of policies that were changed. So things like the requiring approval of ministers or approval of, for example, central agencies on contracting, on communications. I'm sure the member might recall, actually, that we appeared before the Public Accounts Committee on the question of the communications policy, and all of the news releases, technically, of the Auditor General had to be approved by the Privy Council office. Well, that wasn't going to happen. So they never had asked us for it, but that was what the administrative policy was. So we worked through all that, and all of those policies were amended. And it is very clear now in the contracting policy that the agents of Parliament do not have to have Treasury Board approval.
Yeah, I remember the threat that was there too, Sheila. It had a lot to do with it. I've only got a little over a minute. I would just ask you, we spent a lot of years together on public accounts, dealing with your reports and your findings, and you spent a lot of time on process, proper process, proper procedures, recognizing the importance of doing things the right way. Given the fact that the Chief Electoral Officer was not consulted, that the Commissioner of Elections was not consulted, that none of the opposition parties were consulted, that the Canadian people were not consulted. In fact, nobody outside the Conservative Party of Canada was consulted on this bill before it was tabled in the House. Your thoughts on bringing in a complete change to the Electoral Act, as we've seen here with the Unfair Elections Act, without any of that consultation at all? Just your thoughts on that as a process in terms of the public interest.
Well, Chair, I can really only base this on my experience. When I was Auditor General, we had amendments to the Auditor General Act 3 or 4 times, and certainly each time we were consulted. Our views were sought. We were asked if there were, any unintended consequences that could result from that. Was this really what, would this amendment achieve what, we were all wanting to do? And I always thought it was a very good process, and I would have thought with something as important as the Elections Act that there would have been broad consultation.
Thank you. Thank you very much. Mr. Sims, 7 minutes.
Thank you, Chair. And I just want to read something in for the record. This is from a blog from a gentleman named James Sprague, who worked in several had several positions here, especially through Elections Canada. And here's what he said that may dispel some of the myths. Currently, the only legal authority that the Chief Electoral Officer has respecting the exercise of the Commissioner's investigative and prosecutorial discretion is to be able to require that the Commissioners undertake an investigation in 5 situations that go to significant aspects of the conduct. The authority does not extend to directing how such an investigation, once started, is conducted, nor does it extend to stopping an investigation once underway. That's the impression we got from Mr. Corbett as well as Mr. Cote, commissioners past, present. I do believe that the exchange of information is one that is essential in this particular situation. I don't think, to be honest with you, I think this is more of an exercise in isolation than it is in independence. I think the independence could have been achieved within the confines of Elections Canada. If there's one sympathetic view I've heard to the separation, it may have been from Mr. Manning, which talked about the functions of it. But at the same time, there seems to be much of a disconnect between the CEO and the Commissioner, such that I don't think it's particularly onerous on the CEO to get too involved in that situation. We even had one Conservative MP in the media tonight saying it had more to do with the leaks. That was Mr. Jay Aspin in the Hill Times, as why they put it to a separate office. Nevertheless, I put this to you because I want to, if you want to comment on that, please do so. But in Senate hearings today, there was some confusion over whether you had in your office, and as auditor, whether you had the power to compel testimony.
The Auditor General has the powers of a commissioner under the Inquiry Act, which in fact means that the Auditor General can compel testimony, doesn't have to go to a court to order it. The Auditor General can order it himself. Now, I don't know that that has ever actually been used, but it is a provision. It's, I think, Article 13. I had to look it up tonight.
Right.
It does have that power to compel testimony.
Would it be fair to say that you didn't have to use it because it was the hammer that everybody knew you had?
I'm not sure about that. I have a feeling that often reporting publicly that someone did not talk to us was perhaps more damaging than actually talking to us.
Understood. Understood. Mr. Manning, sorry, I used some of your testimony there. Would you like to comment on that? And in particular, I'd like to know about your thoughts about the power to compel testimony as was requested by the CEO and Commissioner.
Well, I could just repeat what I said before. My angle on that division was more trying to enable the chief electoral officer to focus solely on the administrative aspects of the election. I don't see the big problem in making a separation that others do, and I frankly don't think it's as big a problem as being made out.
But for the power to compel testimony, certainly, would you feel that would be an effective tool in case of, like, for instance, the robocalls affair that happened? Do you feel that certainly more evidence would have been put out there and would have led to a more successful conclusion? As far as
yes, I think there's some merit in that, but I don't think that's the sole or the main way of dealing with these election abuses. One of the things that concerns me, any of us that are elected people have heard rumors and rumors after rumors about people doing things, borderline things, illegal things that influence an election in the favor of our opponent. These have been made by all parties over the years, and they can point to different writings. A lot of this stuff is hearsay, and a lot of it's after the fact. And it seems to me, and I don't know what the answer to this is, but there should be some way of kind of clearing the air on these types of charges, because they float around forever. They become part of the urban legends, or the legends of particular ridings. I wonder, when our country does appoint independent election observers in other countries to endeavor to ensure that elections are fair and that there is not fraud, whether there isn't more room for the appointment of special officers to watch particular ridings where these types of rumors have been have surfaced for years.
Where these officers would have the special investigative tools similar to our own Competition Bureau here or the Auditor General. Certainly that would go a long way.
Well, would have the tools that are given to independent election observers in other countries.
But the independence there is obviously achieved. One thing is to be independent, the other thing is to be effective. Wouldn't you agree?
Yes, yes.
Effectiveness, obviously, Ms. Fraser, you touched on earlier, and I want to go back to this because I think it's a very important point when it comes to the legitimacy of an election and the fact that, that people have the ability, and I think Mr. Janeski touched on this as well, the ability to investigate. The independence issue, to me, seems like we're focusing too much on this and the effectiveness of people to investigate potential fraud, dare I say fraud, but also the term irregularities that are involved here. Because a lot of these irregularities are just that, irregularities, and treated as fraud, and that's why I think we're doing such a disservice to this country by throwing out the system of vouching when there are alternatives that could help improve the system. And I can ask you both, Mr. Janeski and Ms. Fraser, to comment on that.
Well, in terms of the issue of vouching, it was actually part of the case that I brought forward. However, I disagree that vouching should be eliminated. If properly administered, vouching enfranchises, and removing vouching disenfranchises, especially vulnerable demographics. It takes away their voice. And in regards to the issue of irregularities and fraud and how do we investigate, Mr. Lukowski raised a very important point. What if it's Elections Canada officials themselves that perhaps need investigating? I believe that the Elections Commissioner should not be under the wing of the government. However, in those particular cases, a special investigative unit should exist to help investigate those cases and clear the air, as Mr. Manning said. These sorts of situations are untenable if they're allowed to continue for years, and there have to be timelines within which these investigations take place.
Thank you. Thank you very much. Mr. Sims, your time is complete. We'll go to Mr. Lukowski. 4 minutes, please.
Thanks very much. Just a couple of quick points to Ms. Fraser. I read, and I'm assuming this is correct, it was regarding your testimony today at the Senate, where you talked about vouching, or at least the provisions of the bill, and said that your daughter, under the current provisions of the bill, would not be able to vote. A couple of points there. She's a university student, I take from your comments, living at home, so she gets all her correspondence, her utility bills, whatever, via email. I mean, a couple of things. Obviously, there's 18 months before the next election. I would assume she would be able to get the proper identification, or at least the confirmation of address by that time. Secondly, even though she's getting perhaps all of her information via email, I know that you can request written transcript, hard copy transcripts from the university, which would be sent to her home, would it not? And then would that not be able to comply with the regulations contained in Bill C-23? So I guess my point is, when you say that she wouldn't be able to vote, with all the greatest of respect, I just can't agree with that, because there's certainly ways that she would be able to vote. She would just have to go that extra mile by asking for a hard copy rather than electronic.
I agree with you. My point was that today, if an election was called tomorrow, based on the information that she had right now, she does not have any of the documents that prove her residency.
One of the things we've been... I'm sorry.
It's a lot. I think it's a lot to ask. I don't know. I mean, why would my daughter go and get that document? It's because her mother would be after her to go and get it. I think there are a lot of young people who just, it would be too complicated. They wouldn't, and there are a lot of people, now this is, we're, in a certain category of Canadians, there are a lot of Canadians who just would have great difficulty doing that. So I'm just concerned that there will be people who will not be able to vote because of, and especially not being able to prove their residency.
Yeah, the point I was trying to make is that we've heard a lot of people who say that, well, it's too difficult. I could probably get the information, but it's just too difficult. Frankly, I think that if someone wants to vote, it believes in their right to vote and wants to participate, whatever effort it takes to produce the correct identification at the polls, to confirm residency and address, which are both required to vote in a particular poll, I don't think that's too big of an effort to ask of Canadians. One last point, because I know we're running out of time. When we talked before about the level of cooperation that you see is needed between Elections Canada and the Commissioner of Elections, and you said you don't see anything in the Act that really allows that to happen if they're moved out of Elections Canada. Is there anything in the Act that you see that excludes Elections Canada from talking about investigations and this dialogue back and forth?
No, but my understanding of issues like the Privacy Act and others is that there has to be an explicit approval given to be able to share information. You might want to consult, the Privacy Commissioner on that, but I think there has to be a specific provision in order to do that.
My question would be, because I think there's all indications that they would want to give as much information as possible to assist. So if that, I guess, impediment that you see might occur right now, if that was resolved, would that change your view?
I think that moving the commissioner is feasible. I mean, I think that he will be able to carry out investigations. There is the question of exchange of information and the efficiency, and the commissioner raised other issues. But obviously, I think that exchange of information and the cooperation between the two agencies is the crux of the difficulties. Yeah.
Let you start something else, but while I finish these comments, your time will run out. So we'll now go to Madame Latendresse for 4 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I'd like to thank you for being here today and for assisting us in our study of Bill C-23. I'd like to raise a particular aspect of the powers of investigation that haven't been raised this evening. It's another provision that's been ignored in Bill C-23, that is the CEO and many experts have been calling for a long time, and that is to call on political parties to provide documentation on election spending to ensure that they are compliant with the Election Act. Currently, Elections Canada can ask that from political candidates and for nomination candidates and for leadership candidates, but not of political parties themselves. Now, that has been called for. It has been demonstrated that that kind of measure would concretely assist Elections Canada to combat fraud and investigate irregularities. Now, why is this provision not in the current legislation? No. Obviously, I wasn't aware of it, but this is a question that needs to be asked of the government. Political parties do receive substantial amounts in the realm of $33 million. Now, accountability is required for much less. This is an era of transparency and accountability, so I think that it would be logical that this provision be applied. Now, also, if you enable political parties to solicit funding during an election campaign, how can the CEO ensure that these are attempts to solicit funding rather than to encourage people to vote? You need an authority to require these documents and information and to conduct the appropriate verifications. And I think that this provision is indeed crucial. Well, that's very welcome comment. It has been indicated that the provision that stipulates that political parties contact donators don't have to disclose these donations. So this is for $20 and more. So someone who gives less than $20 may remain anonymous. The CEO was very clear that there was no way to appropriately follow up on that kind of thing to make sure that the proper measures were applied. Now, Mr. Manning, this measure concerns about $33 million that is given to political parties with no documentation. What do you think? Don't you think it should be in the current legislation? In the bill, rather?
As much transparency as possible, but transparency's got to include not just dollar contributions, it's got to include particularly contributions in kind, manpower contributions, which are often made by interest groups, labor unions, and companies. So I do think the more transparency, the better, but you've got to include more than cash contributions to political parties.
Absolument. Je suis complètement d'accord.
Absolutely, I agree entirely. I'll leave the rest of my time. No, 15 seconds, well.
Yeah. I'm going to go to Mr. Reid instead.
Thank you.
Mr. Reid,
Thank you.
4 minutes, please.
Do I get her 15 seconds as well?
You had it, but not anymore.
You have it. You don't now.
Okay, all right, thank you. So my questions are for Mr. Manning. Well, first of all, I should, in the interest of the full disclosure that everybody seems to be inspired by right now, I may as well admit that I used to work for Mr. Manning. I was hired about 20 years ago to work as a researcher for the Reform Party caucus, and I must say the years that I spent working for you were a real delight and a real education. I wanted to ask you about the Section 8 changes, the restrictions on Elections Canada advertising, and I hope you'll see the problem that I'm struggling with. Elections Canada and other electoral authorities, including Elections Quebec, I just saw an ad they had on the side of a bus recently. They put motivational ads, out where they can, posters. They put them on TV and so on, either trying to encourage you to vote or reminding you that it's your duty to vote, that kind of thing. I've never seen any evidence that it does any good at all in terms of increasing the vote, and I've never seen any report from any of these electoral authorities. In all fairness, I have not done a scientific search, but I haven't seen anything showing that it works. So it seems to me the most effective way of trying to get people out to vote is to try and deal with the basic impediments that they face. Disabled people who can't get out of their house, people who don't know about advanced polls or the fact that they can vote by mail, who are shut in, all of that kind of thing. I guess I'm looking for your thoughts on this in the face of what seems to me to be a request from so many people that they be given a power that the agency has not been able to exercise, to my view, very effectively.
Well, I agree with you that if these efforts by Elections Canada or the elections offices in the provinces to increase participation simply consist of advertising campaigns and urging the obvious that people don't respond to, that if that's all they can do, then that is insufficient. And I think most of the election offices themselves agree with that. But I therefore think that greater efforts and more profound efforts need to be made to try to increase participation. That there is more need for scientific studies to get to what is the root of people not participating in the process. I think some of that could be done by the elections offices, but I just think everybody that's a player in the game, Elections Canada, the parties, the candidates, has got a vested interest in increasing this. The reason that I am actually in favor of restricting the vouching provisions is that I think the emphasis should be on getting people to get their name on the list. And I think that's where the emphasis should be put, and not on facilitating voting by those whose names are not on the list. I think that's one of the reasons why most of the provinces don't allow, many of the provinces don't allow vouching. Those of us that have been candidates for public office know that one of the easiest and most credible entrees into the mind of a voter is when you knock on the door and go to a house and you ask, are you on the voters list? And when they say, well, I don't know, or no, I'm not, then we make the effort, well, you know, whether you like me as a candidate or anything else, one thing I can do for you is get you on the voters list. So I guess I'm just making a plea for any and every effort to increase the number of names on the voters list is a good thing. I do also reflect on the fact that in the civil rights movement in the United States, this voter registration business was particularly effective in getting people who had been marginalized, people from minority groups into the process. Get registered. Get your name on the list. And I think empowering the elections candidate to pursue that objective in better ways, as you suggest, than what we have in the past would be a good thing. One other thing that's occurred to me is that maybe another way for the government to come at this is to put out a request for proposal, a genuine request for proposal with some funding behind it, saying, is there anybody out there in the country that can figure out a way to get better participation in elections? And look at the proposals. Let Elections Canada be one of the people making a proposal. This student vote group, which I think have done a good job on trying to do this with young people, that may be another route to trying to address this problem.
Thank you, Mr. Manning, and I thank you all. Thank our whole panel for being here tonight, and we're going to call that to an end and say thank you very much. And we will adjourn, and we'll see you all tomorrow here in this very room.